Frank Bisimwa versus St. John Fisher College. I think that's what he's saying.
Sounds good to me. That's how I would say it.
Okay, go ahead.
Mr. Egan.
Thank you. Good morning, Your Honor. May it please the court. Josh Agins on behalf of the appellants, St. John Fisher College and Dean Terry Travaglini. Your Honors, there are three primary buckets of issues that the court needs to decide on this appeal. The first deals with the defamation claim. The second deals with the breach of contract claim as against Dean Travaglini, who was not a party to the contract at issue. And the third deals with the breach of contract claim as against the college. And I'll take the issues in that order, starting with defamation.
Well, I'm gonna take them in a different order. Let's first deal with Dean Travaglini. It seems to me we can perhaps dismiss that really relatively quickly because, as you say, she was not a party to the contract, and as long as she acted as an agent of the college, she can't be personally liable, right?
That's absolutely right, Justice Peredato. I honestly, I really don't think much more needs to be said about that. I guess I would just suggest that that issue be reversed explicitly, so that there's no question in the 7th Judicial District Commercial Division that you can't be sued for a breach of contract when you're not a party. But I agree with you that issue is an easy one.
Next one. Then.
Your next issue is maybe the defamation.
Sure. Let me address the defamation points then. There are 4 independent bases to reverse the lower court's decision and reverse the defamation claim. The first is a threshold issue that the court has to resolve before even getting to the elements of defamation. That issue is one that the lower court skipped. And that's the issue of the hold harmless release that appears on page 69 of the record. It says, quote, "I do hereby authorize the release of any and all information regarding me, however personal and confidential it may appear to be. I agree to indemnify and hold harmless the agency and the persons to whom this authorization is presented from and against."
Counsel, let me just interrupt you. I'm just going to interrupt you. I'm not so sure that's your strongest argument, because it seems to me that he signed those authorizations assuming that the college was going to comply with the agreement and not disclosing the information he says was agreed not to be disclosed. But I think actually the more relevant argument, or the stronger argument perhaps, is whether there is enough on this record to actually establish defamation by implication.
That's another issue, Justice Peredato. I would say, though, with respect to the release, this is a threshold issue. You don't get to whether or not there was authorization or whether or not the statement is defamatory until you get past that threshold issue. And that release is clear and unambiguous. And what the lower court did, and what respondent continues to do on this appeal, is to conflate 2 separate issues. One being the legal effect of an unambiguous release, with the second issue, which is authorization under defamation law.
Now, when you talk about the release, are you talking about the release that was given to Buff State or to UB, or both of them?
Justice Smith, I think that was Justice Smith. I'm talking about the release.
Justice Peredato.
I'm sorry.
I know it's hard to tell who's talking with the mask. I'll use my hands, then you'll know I'm talking.
I'm referring to the hold harmless release on page 69 of the record that was sent to Buffalo State. And the reason that's the release that I'm focusing on is because there's only one defamation claim that falls within the statute of limitations period of 1 year prior to commencement of the action. The only viable claim, but the only timely claim, rather, is the one with respect to Fisher's letter to Buffalo State. So it is the release on page 69 of the record that I'm referring to. As I said, the issue of authorization under defamation law is an entirely separate issue with a separate legal standard that the lower court conflated with the unambiguous reliefs, and its legal effect. Authorization is an element of any defamation claim. A communication cannot be defamatory or actionable under defamation if it was authorized by the plaintiff. This is what the lower court said with respect to that issue. Plaintiff did not authorize the inaccurate rendition.
We know what the lower court said. You don't have to read that.
Sure. Well, what the lower court said was contrary to well-established precedent, including cases by this court in Park and Teichner, which say that the standard for authorization and defamation is reason to anticipate. When he signed that release and sent it to Fisher and asked Fisher to communicate with Buffalo State about his disciplinary history, did he have reason to anticipate what Fisher would say? And the answer to that question absolutely is yes. All you have to do is look at his own allegations in paragraphs 62.
Yeah, he had reason to anticipate because they had done it already when in releasing to UB in Stony Brook.
It was the same letter, Your Honor. The first letter went to UB in the spring or summer of 2017.
That's what we're saying. That's why you have reason to anticipate that. Is that what you're saying?
Absolutely. And I would suggest he can't escape the facts that he alleges in his own complaint. He says that because of what the college communicated to UB, he decided to do things differently for Buffalo State. And he reached out preemptively, his word, to provide context. So again, it's inescapable on his own allegations that he had well more than reason to anticipate the communication. He knew exactly what would be communicated because it had happened before. And I will get back to Justice Peridotto's question about defamation by implication. As Your Honor pointed out, this is not a traditional defamation case like I suspect the court is used to seeing. As plaintiff framed it in the complaint, and as he argued it below, the claim is one for defamation by implication. And to my knowledge anyway, this court has not decided a defamation by implication case. We've not found one. I don't believe respondent cited.
No, you're right. You're correct.
So, but lucky enough,
some of the other departments have some.
First, second, third, all have, and they've all come out.
Wait. You know what I'm going to ask you to do is listen to the question and listen to what the justices are saying, and then respond. But don't try to talk over them. Okay?
Certainly, Your Honor.
Now go ahead.
Well, as was pointed out, the first, second, and third departments all have held that defamation by implication requires a heightened pleading standard. Right. Because in its essence, it's an exception to the general principle in defamation law that you can't be sued for truthful speech. That heightened pleading standard appears nowhere in the decision below. And the letter to Buffalo State on its face does not satisfy that heightened pleading standard. It does not affirmatively suggest.
I think we have that argument, and I'm going to suggest you go on to your next argument just because you should be cognizant of your time.
I'll do that, Your Honor. The last argument deals with the breach of contract claim as against the college. And I would direct the court to paragraph 13 of the settlement agreement. Respondent's position, as the court I know is aware, is that the settlement agreement did two things. One, it vacated and reversed the disciplinary finding of responsibility. And two, it expunged a notation on his transcript. The settlement agreement only does the latter. The college was not willing to go so far as doing the former.
It was not willing to go as far as what?
The college was not willing to go as far as vacating and reversing the finding of responsibility against him that stands.
But it did agree not to disclose any records to third parties relating to the allegations, relating to the incident, to the hearing, to the findings. That's very clear in the agreement. And I know you point to paragraph 13, and I know in your brief you argue that because the college could retain the records, and because the law then authorizes them to disclose when there's a proper authorization, that means there was no breach of contract. But the problem with I see with that argument is that you agreed by contract not to disclose the record. So even though the law normally would permit you, when you receive an authorization to disclose the records, you made an agreement by contract not to do so. And it seems to me like what would be the point of this agreement if records could be disclosed with any sort of authorization?
Right. So I think the answer to that, Your Honor, is to ask the question, what would the parties have done? Plaintiff was applying to other institutions. And ostensibly, in order to complete his application, he disclosed his disciplinary history. Remember, he disclosed the disciplinary history before Fisher communicated anything to anyone. And because he disclosed
Not to UB. Wait. Now I think that's not correct. The very first disclosure was to UB, right?
Right.
And then to Stony Brook.
That's right, Your Honor. On page 60, page 64, 63 and 64 of the record are the letters between plaintiff and UB regarding his initial disclosure of his disciplinary history. That's what triggered the request from UB initially for an authorization so that Fisher could communicate as well. So there absolutely was, and it is in the record.
So you're saying because of the plaintiff's letter, that kind of authorized Fisher to breach the agreement?
No, Your Honor. I'm saying that because of his authorization that he signed and submitted to Fisher, asking for Fisher to disclose his disciplinary history.
But he was under the impression from the agreement that they were not going to disclose that part of it. That's the point.
Well,
I understand your argument, but I'm not so sure we're all on the same page. But I think we understand that argument.
Right, and so I guess then the logical conclusion of his argument is that the college, Fisher would just say nothing. If that's what he's saying, if his position is that
that's what the agreement said that should be done. It said, you can disclose things other than the violations found at the student conduct hearing. So even though he gives an authorization, it's reasonable for him to assume that it's not going to include that material.
Otherwise, there would be no reason for this agreement to begin with.
Your Honor, if Fisher disclosed nothing, he would have been guaranteed to be denied from those institutions because he wouldn't have completed his application. The question is, does the settlement agreement prohibit a disclosure under these circumstances? When he asked,
that is the question. That is exactly the question.
And I think there's no provision that forecloses such a communication when it's asked for by the plaintiff himself under these conditions.
Okay, I will look at that very carefully. Do you have anything further?
Your Honor, I would like to go back to one last point on defamation, which is the qualified privilege point, and I won't belabor it, but I will just say the lower court concluded that because qualified privilege is an affirmative defense, it can't form the basis for CPLR 3211 motion, that it was premature on this posture. That used to be the law. The Court of Appeals has said otherwise more recently in 2015 in the Park case. Qualified privilege is an appropriate basis for pre-answer dismissal. And because that privilege attaches, the question is whether the communication to Buffalo State, which is the only timely defamation claim, whether that was motivated solely by malice. And because we've been engaging in this conversation about the authorization and its meaning, and the context of this case, which is that plaintiff asked for a disclosure, you cannot conclude on the facts that he alleges that the disclosure was made solely on the basis of malice. It was made at least impartially in response to his request. And so
I think we have that argument. Thank you.
Thank you, Your Honor. I appreciate your time.
Go ahead.
Morning, may it please the court, Elizabeth Callahan on behalf of plaintiff respondent Frank Bisimwa. I'll start by responding to Mr. Egan's argument about the release, and I think this can be dispensed with relatively quickly. Defendant seems to be suggesting that there is a distinction between authorization and release, and I think those two things have to be read in concert. The release is part of an authorization to disclose records. The terms of that authorization allow the college to disclose information contained in its files and releases the college from liability that would stem from complying with that authorization. However, pursuant to the settlement agreement, the references to any disciplinary action shall be expunged from the college's records that are made available to third parties. So if the authorization only allows the college to release information contained in its files, and the disciplinary information isn't supposed to be in its files, then St. John Fisher is acting outside the scope of the authorization and thus isn't protected by the release. With respect to the authorization, the defendant is essentially arguing that the plaintiff has authorized a defamatory statement by inviting a disclosure about himself, having reason to anticipate that the response might be a defamatory one. And I think that's the important thing that we need to focus on, is the reason to anticipate portion of it. Essentially, the argument that they're making boils down to the fact that Mr. Bisimwa should have known that the college would breach its agreement and disclose this information that it shouldn't have disclosed. The fact remains that Mr. Bisimwa had an agreement with St. John Fisher. The agreement was that any mention of his disciplinary history was supposed to have been expunged from his record. So, we're not talking about a sophisticated plaintiff. This is a young man who's a refugee from another country. He's going through the college admissions process. He had to execute these releases to get his information from St. John Fisher to go to a new school. So the fact that the settlement agreement existed means that he had a credible reason to believe that they wouldn't disclose those expunged records.
How about the defamation by implication claim?
Sure. So with respect to the defamation by implication claim, the Fourth Department hasn't accepted or hasn't articulated a standard for what should be included in a defamation by implication claim. We would argue that, the heightened pleading standard doesn't necessarily apply, but even if it does, plaintiff has met it. First,
it seems you would have to show. It seems that there are a couple of leaps that you have to make that I'm not so sure you can make. And this is assuming we accept the heightened standard that the other departments have accepted. That at least the second part of the standard is that you have to show that, or it has to imply that the declarant either intended or endorsed the inferences. Let's even assume we get to the inferences, but how do you? I don't know how you get there.
I think there are two pieces there. Number one, as alleged in the complaint, Dean Travaglini, the person who was making these representations, was aware of the fact that this settlement agreement had been entered into and that these had been expunged from Mr. Bisimwa's record. So the fact that she made these representations knowing full well that they had been expunged from the record leads to the inference that she intended for the recipient to believe that they were still on his record.
Well, but that's not what she revealed. She revealed that these actions had taken place. That's actually not untrue.
It's not untrue, but the fact that she revealed it without indicating that they had been expunged from his record, it's a half-truth that leads to a false implication. The implication here, it says that he was found responsible.
In the record, in your papers below, you said that the implication from these disclosures was that he had a criminal conviction, that he was convicted of rape. And I don't know how you make that leap from these disclosures.
Well, the disclosure says that he was found responsible for sexual assault with actual harm. The combination of those terms, I think, could lead a reasonable person to read it and conclude that he is a rapist. He committed rape without, the additional. Excuse me?
So these are records that are being disclosed by an academic institution, though, not by the DA's office or by a court. So, I don't know how you get from academic disciplinary proceedings to criminal proceedings.
Even if we don't get to criminal proceedings, I do think that the implication is still that he has done something, morally egregious, that he's engaged in some kind of sexual impropriety. So even if we can't get to the, a reasonable reader would conclude that he's a criminal, a reasonable reader would conclude that, yes, that the college found him responsible for what appears to be something resembling rape. And furthermore, the second item that I would point to is the complaint alleges malice in a variety of ways. That Dean Travaglini was very close with the complaining witness, that she attended the trial, that she was dismayed as the trial was over, that Mr. Bisimwa was found not guilty, and the complaint suggests that she went out of her way to get in his way and railroad him from applying to future colleges. So I do think that I think the complaint on its face does enough to suggest that she explicitly endorsed that inference.
Do you have anything further?
I would just like to briefly touch on the qualified privilege. The qualified privilege, essentially, even if it were appropriate to deal with qualified privilege on a motion to dismiss, the qualified privilege really just shifts the burden back to the plaintiff to show that there was malice. I believe that, as described previously, the complaint does enough to allege actual malice, and at a minimum, it's a question of fact that can't be resolved at this point.
Thank you very much.
Thank you.
The Fitness Institute, Inc. versus Ismet Halleck.